Hi, I'm John Rogitz. I'm a patent lawyer, and today we're going to talk about various time requirements in the patent statute for filing patent applications. There are several pitfalls in here, and we're going to talk about them, and we're going to conclude with maybe some ideas about how to minimize the risk. No country on earth gives an inventor forever to file for a patent application on an invention. We're going to talk about the US primarily here, but we will get to ex-US jurisdictions briefly. Under 35 USC 102, an inventor has a year from the earliest public disclosure or sale or offer to sell an invention to file a patent application. If the inventor goes a year and a day from the earliest such event, the inventor will be barred from getting a patent. Whenever statutory bars are involved, such as in statutes of limitations, of which Section 102 can be considered to be one, there are traps for the unwary. The first trap in the patent context is what qualifies as a public disclosure or sale. Just stating at a trade show, for example, that you have a new rocket ship to Mars without telling what the underlying technology is does not constitute a public disclosure. But at least so you might think, your marketing colleagues may give people a closer look under the hood than you had planned or even aware of. So even when you think you're making a disclosure that doesn't count, you or someone else might be wrong about that. With sales, first sales or offers to sell, the traps propagate because courts dislike giving inventors more than the statutory period of monopoly to make money on their inventions. Thus, a sale of a product that contains hidden and undisclosed technology, such as, for example, a computer game program or a computer program that can't be detected simply by using the product, starts the clock ticking, even though no one buying the product may have any idea of what the technology is. Many patent lawyers have had, oh, by the way, moments when a client assures them that no disclosure has been made, but now you mention it. Yes, the software has been running in marketed products for some time now. Is that a problem? Well, yes, it is. It can be. So it is important to file within the grace period afforded by law, 1 year in the US. And now comes further traps for the unwary. The document that will become the patent is called a utility patent application. It contains a complete description of how to make and use the invention, followed by a series of numbered single-sentence paragraphs called claims, and it is the claims that define the scope of protection. The claims may and typically do change through prosecution to avoid the prior art. But because utility patent applications cost many thousands of dollars just to file, the US, like many other jurisdictions, provides a second way to enter the patent process, namely by filing a provisional patent application. This is an application designed to contain only the technical description and need not, but can, include the claims. The idea is that a lay inventor with no legal training can file his technical description without having to pay a lawyer to write the critical claims, and then within a limited time, a year it so happens, try to sell or develop or otherwise exploit his invention. And only once he is confident that he can make money from it, convert the provisional, which never gets examined, much less issued as a patent, to a utility patent application. Now here's where the trap comes in. When converting a provisional to a utility, it is sometimes the case that the person now responsible for writing the claims that the provisional is designed to avoid finds that he or she must add subject matter to the technical description to support the claims. If that added subject matter makes it into the claims, and it often does, the claim may be expected to be deprived of the benefit of the provisional filing date, even if the patent, once it issues, will have printed on it a priority claim to the provisional. If the provisional was filed, for example, 6 months after a disclosure, and then the utility was filed a year after the provisional, under these circumstances, the claims of the utility will likely be invalid because they fail to obtain a filing date within the 1-year bar period of 35 U.S.C. 102. This has happened in the past, and it will happen again, in part because the Patent Office rarely actually checks to see that a utility patent application claiming priority to a provisional actually has support for its claims in the provisional. Your opponent in litigation will do the homework that the examiners typically do not do. To complete the traps for the unwary, the U.S. is one of a very few countries that have the concept of a grace period. Most other countries do not. They have what's called an absolute novelty rule, meaning that before any public disclosure or sale, they expect a patent application to have a priority date that's earlier than any public disclosure or sale. And so the way most U.S. inventors and companies handle this is they file in the U.S. before any public disclosure or sale, even though they have a year grace period here. And then they can later file elsewhere, claiming priority to the U.S. filing date, which will get them past the absolute novelty rule of, let's say, Europe and Japan and China. The takeaway, I think, for all of the reasons just mentioned, is to file a patent application before any public disclosure or sale, particularly because even if you disclose the invention publicly and file within the year grace period, what are you going to do if somebody hears your disclosure and beats you to the patent office? Before the United States shifted from a first to invent to first to file system like the rest of the world has, you had something called an interference proceeding that you could prove that you were actually the first to invent and should get the patent even though you were the second to file. That's no longer available. And so for all of these reasons, to take the grace periods off the table, to take the bars off the table, to take the potential for someone beating you to the patent office off the table, a utility patent application, preferably a utility patent application with a complete set of claims, should be filed before any public disclosure or sale as soon as the inventor has developed the technology to the point where the inventor can explain how to make and use the invention. Once you get to that point, you are ready for patenting, as the Supreme Court said in Pfaff v. Wells, and you be best advised to tell your clients that they should not wait, regardless of any grace periods or regardless of the absence of any plans to disclose or sell the invention soon. Thank you.